medals tally at the Paris Olympics 2024 by winning a bronze in the men's 50-meter three positions final. So far, Bharat has won 3 bronze, all coming from shooting. The centre on Tuesday informed that 755 applications have been approved across 14 key sectors under the Production-Linked Incentive or the PLI schemes. An investment of 1.23 lakh crore rupees have been realised till March, resulting in around 8 lakh jobs. In good news for the coal and mine sector, Minister G. Krishna Reddy has informed the Lok Sabha on the 31st of July that Bharat has registered its highest ever coal production in a year during the financial year 24 at 997.828 million tonnes, reducing any coal shortage concerns. The domestic coal production for financial year 24 was 11.71% higher than when it was recorded back in financial year 23. The Skill India Digital Hub, a digital platform to synergize skill development, has reported around 88 lakh registrations and 7.63 lakh candidates have enrolled for online courses. The minister said the Skill India Hub now has 752 online courses amounting to 7.37 lakh minutes of digital content for learners. The platform is being primed to be integrated with MSMEs and facilitate access to entrepreneurship schemes for job seekers. And Bharat's ratings, in fact, the India Ratings and Research has upped Bharat's GDP growth forecast for the current fiscal to 7.5% from 7.1% projected earlier on the expectation of improved consumption demand. It said that the ongoing growth momentum led by the government's capex, deleveraged balance sheets of corporates and banks and incipient private corporate capex cycle has now found support from the union government's budget. Let's now quickly move on, ladies and gentlemen, and set the pace on this edition of The Right Stand. We've got multiple stories to cover as we try and break format and get you more from the news cycle here on The Right Stand. All that impacts us as a nation and its people. First up, our top focus, the Supreme Court's big declaration, subclassification permissible within the scheduled caste to give separate quotas for more backwards. But the Rohini Commission report, which was submitted to the President last year, is yet to be tabled out in public. That is with respect to the OBCs. It has learned from reports that the Commission addresses Hindu-Muslim anomaly in the OBC quota for occupational groups. Almost a week after the civic apathy that took lives of 3 IAS aspirants, the capital has inundated again. City came to a standstill on the 31st of July. There was massive traffic chaos with citizens reaching as late as 2 a.m. Life thrown out of gear totally, just with about 155 millimeters of rainfall within just an hour. The Aam Aadmi Party yet again coming under political fire, even as the common man taken for a right royal ride. A big verdict, meanwhile, by the Allahabad High Court in the Krishna Janmabhoomi case. Big loss for the Muslim side and a big victory for the Hindu side. In terms of the maintainability of 18 suits that was upheld by the Allahabad High Court, hearing to continue from the 12th of August. A shocking incident in Lucknow. Woman groped and harassed in Uttar Pradesh's posh Gomti Nagar area. The Chief Minister sending out a stern warning saying no sadbhavna, a bullet train jalegi, even as he named the 2 accused. And this happened in an inundated road while there were revelers in the rain. And a passerby was harassed, especially the lady. More exclusive inputs coming through later on the show on Pakistan's massive infiltration bid via Jammu. News 18 has accessed exclusive details, images of POK launchpads and terrorists. Manoj Kumar Gupta getting us these details. And of course, parents, an alert for you. Don't leave your child idle with their instrument on which they can consume online content, especially gaming. It could be the scariest of things. There is a blue whale kind of redo that's happened. We've had a young life snuffed out towards an online game where he said XD and log off and jumped off a high-rise building. We'll get you those details too. But first up, the Supreme Court has upheld the quota within quota for marginalised among the scheduled castes and scheduled tribes. The big highlights. First up, classification amongst the reserved categories permissible. The second highlight, SC/STs cannot be considered integrated or homogeneous. Subclassification is possible if supported by quantifiable data. State cannot earmark 100% reservation for a subclass. And of course, identify the creamy layer, take them out of affirmative action fold. Big statement this. The former ASG Vikas Singh ji is with us. And we should also have Dr. Anand Ranganathan joining us in a bit. Vikas Singh ji, namaste. Thank you for your time. I know you're on the move, but let me quickly ask you, sir, how would you see the court's judgment? A constitution bench, 6-1 verdict, and multiple opinions coming through in their submissions. Your thoughts, sir?
So this is a very landmark judgment because it is very progressive. So, in society, we have to look at how the society is evolving and how our experience has shown as to reservation in the present form, whether it is still the best form or not, or whether there can be some improvement in it. Now, interestingly, they have said that the states can, provide for either a creamy layer or a sub-classification while providing for reservation. But although that issue was not there, even the president, in the presidential notification, if you see in 341, even the president can create a subgroup within the scheduled caste. And the presidential notification also, taking a cue from this judgment, can say that within the scheduled caste, only this will be counted as scheduled caste. So the classification of scheduled caste itself can be changed by a presidential notification under 341. Now, what they have done, they've gone a step further. They say even the state, while providing for reservation, may say that, all right, these are the scheduled caste people, but within them, I will, subclassify and say that these are people who have already benefited or who are above a particular level, or there are some, because of some, empirical data that they are able to collect to show that this, within the scheduled caste, classification, some of them are more backward than the rest,
Right.
and they need some special attention, and they can provide for reservation for them as well. And Justice Pankaj Mittal's opinion is, I think, very, very instructive. He says that you can also say that only one generation should get it. And he also says that reservation should not be thought of as the only method of empowering the downtrodden. You can also think of ways to, empower them. And I have also felt from the very beginning that rather than giving them crutches, it is better to empower them by giving them more, intense education, more quality education, more facilities to get educated, and ensure that they come to the level of the rest in the group, and not suffer the stigma of being, appointed because of this policy of reservation.
But is this going to
And
force? Is this going to force, Vikas Singh ji, a relook on the whole reservation aspect altogether? Where does the economics of it come through? Because you referred to Justice Mittal, and he said that the one is one generation only reservation once they are elevated. The other aspect is this entire creamy layer breakdown, saying anybody with an income of more than 8.5 lakhs falls out of the entire reservation block. Is this all possible? Should the economic aspect of it, forwardness, backwardness economically, also weigh in heavily along with the caste groupings?
if I'm not mistaken, Justice Gawai has also mentioned about the creamy layer, and there should be a creamy layer. So why I say it's progressive is because this judgment will force the policy makers and the administrators to relook this whole concept of reservation and try and see that it remains a instrument of social change. It remains a method by which you are able to empower the really downtrodden amongst the scheduled castes. Now, just take an example of somebody who already gets into the IAS. Now, if his son is also, and then obviously his children get the best of education, and obviously they are in the best of schools and best of facilities. Now, if his son also takes the benefit of reservation, in some way he is depriving somebody more deserving than him by taking the benefit of reservation. So all this judgment, that's why I said it's progressive. It will definitely force the policymakers and the people sitting in power to have a relook in this whole concept of reservation. Reservation probably will have to stay, but there could be definitely fine-tuning of reservation to see that it really reaches the right person in the amongst the scheduled caste or the scheduled tribe group, rather than remaining a benefit for a few who are because of their being better within the scheduled caste are able to take the benefit of the reservation. So, because within the reservation also there is a quota. So, it's not that everybody in the scheduled caste gets appointed. So, the person who gets appointed is the one who has a certain amount of more facilities than the others who don't have the facility. So we have to reach to that last man, and that's what this judgment will, open up the thought about.
Well, let's not forget merit, and there should not be any compromise on merit, even as we try and create these classifications and sub-classifications.
No, that is why I said this thought of having a method of, instead of a reservation, thinking of something else is also a very, very important thought which has been, flagged by Justice Mittal in his judgment.
Thank you, Vikas Singh ji. Thank you. And on short notice, you've joined us even when you're on transit. Thank you for speaking with us. Anand Ranganathan ji is with us, author, political commentator, and also a scientist himself. Has some very strong views on this entire reservation aspect. But before we go across to him, quickly, ladies and gentlemen, even as we talk about the court's judgment, there's something that's pending and it still lies with the government, tabled with the government. This is the Rohini Commission report on subcategorization of OBCs that was submitted to the President last year, but the government is yet to make the report public and the findings of this report public. Now, report suggests that the panel found that in some states, Muslims from certain occupational groups have OBC status while Hindus don't. The Rohini Commission decoded it was actually instituted on the 2nd of October 2017, led by Justice G. Rohini, ex-Delhi High Court Chief Justice. Four-member panel was to ensure more equitable distribution of quota benefits among OBCs. BJP-led NDA had proposed subcategorization in 2017. The commission set up thereafter. Commission was set up by the President, mandated under Article 340 of the Constitution. The report finally was submitted to President Draupadi Murmu on the 21st of July 2023 after 13 extensions. Rohini Commission's goals were to investigate the conditions of socially and educationally backward classes, propose steps for improvement of backward classes, had to examine the extent to which there was inequality in distribution of benefits within reservations, and work out a criteria by which subcategorization within OBCs can also be executed, can be done. Rohini Commission's findings were analysed and more than 130,000 government jobs and admissions to government education institutions that had OBC quota, 97% of the reserved jobs and seats to 25% of the OBC subcastes, and also 25% of reserved central jobs, institutional seats to only 10 OBC communities. 983 or 37% of the 2,600 communities under OBC category had zero representation in jobs and institutes. Only 2.68% reservation was used by 994 castes. Commission's first consultation paper was in December 2019, recommended breaking down of the subcategories into 3 bands: communities receiving no benefits 10%, those with partial benefits 10%, and those receiving maximum benefits at 7%. And the government sources have said that the Commission has found around 200 religiously restricted entries in the central list of OBCs where Hindus belonging to specific occupational communities were not given OBC status, unlike their Muslim counterparts. Dr. Ranganathan with us. So this entire reservation debate now out there with the Supreme Court judgment, the Rohini Commission with the President's office, be it OBCs, SC, STs, are we queuing ourselves up for a thorough reservation relook?
Good evening, Anand. The overarching question would be, would we have the guts to speak the truth and speak what needs to be spoken? But before that, I want to come to this, the judgment itself, because I think in my limited reading of the Supreme Court judgment, I think it's a good verdict, one that is logical and rational, simply because there is no one strata of underprivileged class. There is a gradation of it. Every person belonging to the SC, ST and availing the reservation is not socially and economically deprived at the same level. So it makes total sense to have a quota within quota so that benefits of reservation can go to the most underprivileged class amongst the SC, ST community. Also, the Supreme Court directive that there should be a creamy layer specified in the SC, ST quota as well is most welcome, because there was no creamy layer criteria. The benefits of reservations were not filtering through to the most deprived of our Dalit community. Hopefully, the Supreme Court will also look at how the reservations, the OBC quota is divided in the OBC quota. I talk here of the, as you said, in your primer Rohini Commission, that found 97% of the reserved jobs and seats go to only 25% of the OBC subcaste. And only 10 OBC communities have taken the 25% of reserved central jobs in institution area. That can't be right. 37% of communities under OBC category had zero representation in jobs. So we also need to put an end to the appeasement done by the politicians and political parties when it comes to dividing the OBC quota. Let me explain very briefly. Backward classes are grouped under category 1, most backward. Category 2A, relatively more backward. Category 2B, more backward. Category 3A, backward. And Category 3B, relatively backward. There are as many as 36 Muslim communities that get reservations under categories 1 and 2A. And in 1995, the Devagowda government gave 4% reservation to Muslims under 2B as well in Karnataka. It was only in 2023 that the BJP government under Mr. Bommai scrapped this 4% quota for Muslims under 2B. Matter is still pending before the Supreme Court, but that has stayed the BJP decision. And now the Congress has reinstated this very quota, saying that all Muslims can avail of this quota. Thing is, as the Backward Class Commission is now also protesting, why then are Muslims also placed under the other two categories?
Correct.
Please remember that the Supreme Court through a 9-judge bench judgment has fixed the upper limit of reservation to 50%, 15% for SC, 7.5% for ST and 27% for OBCs. This is separate from the 10% reservations quota for the economically weaker section. Yes, Muslim classes have previously also been included in the OBC quota, not only in Karnataka but in every state. But to say that every Muslim of Karnataka now belongs to backward class and can now avail of reservation is just bizarre and makes a mockery of the real purpose of why we have reservation in the first place. Finally, just 30 seconds. As far as reservations are concerned, Anand, beyond the hypocrisy of every political party, I have very briefly 2 points to make. Number one, as was reinforced by none other than the Chief Justice of India, Chief Justice or rather Justice Pardiwala, and also Prakash Ambedkar, the grandson of Dr. Ambedkar, that even Dr. Ambedkar wanted reservations for only a limited period of 10 to 30 years. Why do our present crop of politicians not have the guts to implement that? And finally, two, as I said, if giving reservations is a moral obligation, then why are reservations excluded from certain domains and sections? For example, the prominent among them being the judiciary. Why do the judges suddenly think of merit when it comes to appointing their own, but think of quotas when it comes to appointing doctors, scientists and other professionals? Is that not hypocrisy as well?
Well, you have asked a very fair question, and if there are reservations, let there be, but there should not be a compromise on merit. Compromising on merit is perhaps the biggest disservice that we can do to our nation. And also to those who are able and capable, because otherwise that allows the system itself to underperform. Unless the system is forced to perform by giving better education, access to better facilities, etc., this quotient of merit will not be upheld along with giving reservation based on caste and class. Thank you very much, Dr. Ranganathan. Please stay on with us. We got multiple stories to cover. Let's quickly shift focus and get to story number 2 on the right stand, and this is what's happening in the capital. There's waterlogging. There is a huge amount of traffic jams and leakages, and of course, harassment of the people. More importantly, lives have been lost. Citizens continue to be on a warpath over civic apathy in the capital. Look what just about an hour of rain on the 31st did. They have to bear the brunt, us common people. Houses collapsed after heavy rains in Delhi's Sabzi Mandi area. Mother and son drowned in Ghazipur. ITO remains waterlogged with traffic snarls across the city, and citizens continue to raise slogans against the authorities. Delhi witnessed 112.5 mm of rainfall in 1 hour on the 31st of July towards the evening. Alert for heavy rain to continue till about the 5th of August. Schools are shut. Waterlogging has been reported in multiple parts. What the High Court has said while hearing the matter today, Delhi drainage issue, the High Court has actually come out and said, even in the past, on the 25th, the court sought a reply from the Chief Secretary to present desilting timeline. Drains are virtually clogged and can't be cleared overnight. It's imperative to develop a new master plan, they said. On the 10th of January earlier this year, High Court said drainage system is in a very bad state of affairs. Drainage system has totally collapsed. Do we have a drainage system in Delhi or do we don't have it? It is absolutely pathetic. On the 8th of April, the High Court said need for unified and centralized command imperative to solve the drainage issues. City and its citizenry waits with apprehension when monsoons are approaching. Drains are mismanaged. Administrative agencies adopt an ostrich-like approach, wishing flooding won't happen. Need for a vision by administrators to manage present needs and anticipate the future. But here is the thing, ladies and gentlemen. What about us? These drains don't clog themselves on their own, do they? It's all the junk that we throw. So what are we doing as citizens, Dr. Ranganathan? Are we not also equally to blame as much as the civic apathy or inefficiency that's being called out? And more importantly, you and me will be held criminally culpable for driving a car through a flooded road. That person thankfully has now got bail. But what about the officials who've allowed these constructions and these illegalities?
Absolutely, Anand. There are 3 points to make. Number one, and you know me, I have always criticized anything that needs to be criticized. But the starting premise should be that 1 month's rainfall fell in 1 hour in Delhi.
Yeah.
So, whatever contingency you may have for emergency, it just obviously it is burdened to the extreme when you have a month's rainfall falling in an hour. So, no amount of contingency plan or something extra planning can take care of that. Having said that, we have seen even when a day's rainfall falls in 1 hour or rainfall doesn't fall or there is we have municipal apathy, we have malfunctioning to the extreme of all these municipal corporations, the government, state and center. I mean, this is a litany that has gone on for decades. The point of the matter is, when you say, are we also not at fault? Well, Anand, to be fair with you, we pay our taxes. We want better amenities. We want functional, working, sensitive, listening to the citizen, municipalities like that. We don't get it. Now, you talked about illegalities. Of course, as the proverb goes, rules are meant to be broken. Every one of us, if we can get away with it, we break rules. We've seen it speeding or
that's
anything.
Human tendency.
But that's human tendency. But of course, in a rules-based society, there has to be an organization that puts paid to that. So, for example, that will not allow that to happen. Now, when the MCD allows 55,000 illegalities that they've just noted in the last 6 years and doesn't do anything about it, obviously you will have mishaps happening. But here, I also want to point out the role of the judiciary, because if the executive and the legislature are simply not working, or they are at the altar of political expediency, they are not doing what they should be, the judiciary takes over. You may call it judicial activism or what you may. But the fact of the matter is, a few months ago in Mumbai, when 2 children drowned, the Mumbai High Court took suo motu cognizance. Same happened in the Gujarat High Court. It took suo motu cognizance in that the fire that happened in the playground. So why did not the court take suo motu cognizance of those 3 tragic deaths that happened? Why the Supreme Court is completely silent about the chaos that the Delhiites have been witnessing? This is something that the judiciary also needs to answer.
Interestingly, 2017, a report that was led by a panel led by D.R. Karthikeyan, the former CBI director. It was under the aegis of the then Chief Justice of the Delhi High Court, Justice Geeta Mittal. They have actually submitted a report, a comprehensive report on what needs to be done, action that needs to be taken. That report is in cold storage in the courts itself. I don't even know if the current Chief Justices and the current judges know that there is a report already with recommendations. There is a drainage design system, a blueprint that was adopted 8-9 years ago that still has not been implemented in Delhi, and the courts have not said anything.
No, but Anand, just a minute on this, because you've really hit the nerve there, and please don't talk about reports. You see, what happens is, when there is water logging, when the cars or vehicles stall, yes, there is some discomfort. When the roof leaks, of course there is, you feel frustrated. But at least the lives are not lost. When lives are lost because you don't pay heed or pay cognizance to the reports that you yourself asked to be conducted, then who is criminally culpable? I put it to you that, for example, the tragedy that is unfolding right now, it's been 4 days in Wayanad. More than 250 people have been killed. The Gadgil committee and more than 3 other committees have submitted their report during the UPA, during the NDA, that this is an ecological sensitive zone. You cannot have construction there because landslides are waiting to happen. The Congress did not even allow for the report to be made public.
Yes.
Who is criminally culpable there? See, we need the answer.
Here is the thing. They say public memory is very short. 4 दिन रोएंगे, उसके बाद छोड़ देंगे, क्योंकि जैसी बारिश थम जाएगी, सड़कें खुल जाएंगी, लोग भूल जाएंगे. That's the attitude with which they get away. These officials get away, and they'll always say, "I was not there. It was under some other official, so you can't hold me culpable. I didn't know. I tried to do, but I was stopped from executing." So the councillor gets away, the engineer gets away. It's the juniors who get suspended for a little while, and then when things settle down, they'll be brought back into duty. So this is a perennial game, and it's a sad one at that. That's a reality.
I just want to add something. You see, in other domains, this doesn't happen, because if, for example, a doctor can be punished and arrested through medical negligence. Now, there is such a thing as medical negligence. If the hospital says that you cannot administer this or you must administer this to the patient and the doctor doesn't, he is criminally culpable.
Some
Now
will-
I ask you, if for example, under the leadership of Rahul Gandhi and the Congress, a report said you cannot have any construction activity because this will lead to deaths, and the Congress did nothing about it. The MP of Wayanad did nothing about it. The Environment Minister Jairam Ramesh did nothing about it. Are they not? I'm asking this seriously. Are they not criminally culpable?
So they are no longer environment ministers. At that time, Mr. Rahul Gandhi was not the MP of Wayanad. Neither was the councillor currently who's absconding and AWOL for the last 4 days in Delhi was the councillor when these buildings were constructed. Nor was the current Chief Justice the Chief Justice when this report was commissioned. So everybody will have bahanas, and some rules don't apply to babus, netas, and of course those in the Kala Court or in the judiciary. It applies to everybody else. That's a reality, sir. That should change too. Dr. Ranganathan, please stay on. Quickly moving on here and shifting focus on the right stand to yet another big development, ladies and gentlemen. Moving away from the capital chaos to what happened, which could prove to be a big moment for the Hindu Paksha's fight to get back Krishna Janmabhoomi. The Allahabad High Court has dismissed the Muslim Paksha's petition on the Mathura Krishna Janmabhoomi dispute, saying all the 18 cases are maintainable. Now, the Allahabad High Court has actually rejected the plea. The Shahi Eidgah Masjid plea was filed under Order 7, Rule 11 or the 711. That's as it's called. They had challenged the maintainability of the lawsuits filed by the Hindu side or the Hindu Paksh. The High Court has ruled that all 18 suits in this entire aspect are maintainable. The lawsuits were filed by worshippers and petitioners, and they said it's not barred by the Limitation Act or the Places of Worship Act or the Waqf Act or even the Special Possession Act. And the removal of the Shahi Eidgah Mosque from the 13.37 acre complex is what is being demanded, saying it shares it with Katra Keshav Dev Temple in Mathura. And this is an Aurangzeb era mosque that was built after the demolition of the temple. The Hindu Paksh says this land belongs to the deity. And as per the constitution of Bharat, the deity has living rights. Joining us now, Vishnu Shankar Jain and Hari Shankar Jain, not just counsel in certain cases, in petitioners in some. Namaste, Jai Hind, and thank you for your time. Quickly, Vishnu Jain, would like to ask you first up, what do you make of what the court has ordered today?
See, it's a very important verdict which has been delivered by the Honorable Allahabad High Court. The Honorable Allahabad High Court, by way of the present order, has decided 5 issues which had arisen because of the objections raised by Shahi Eidgah Masjid. And those issues were precisely that this suit is barred by Places of Worship Act, Waqf Act, Limitation Act, Specific Relief Act, and the provisions of Order 23, Rule 3A. These were the 5 objections. On these 5 objections, a detailed hearing of around 4 months were held before the Honorable Allahabad High Court, and today the Honorable Allahabad High Court has dismissed the application of Shahi Eidgah Masjid and has held that this suit which has been filed by us discloses cause of action and it is maintainable, and the suit will proceed. The next date of hearing is 12th of August. So the basic argument which we had raised before the Allahabad High Court was precisely that why this suit is not barred by Places of Worship Act, because of 2 reasons. First is that Shahi Eidgah Masjid is a ASI protected monument. So if it's a ASI protected monument as per the provisions of Places of Worship Act by virtue of section 4 subclause 3, the act itself says that this act will not be applicable. Point number 1. Point number 2 is that Places of Worship Act gives the freedom to determine the religious character. In Gyanvyapi's case on 19th of December, the Allahabad High Court has given this finding, and same judgment we had relied upon so far as this issue is concerned. The second aspect was of Waqf Act 1995, and the objection of Shahi Eidgah Masjid was that this matter should not be tried before the Allahabad High Court. It should be sent to the Waqf Tribunal for adjudication. For that, we had submitted that the Supreme Court had delivered its judgment so far as the law point is concerned in a Board of Muslim Waqf in 1979 and in Ramesh Govindram's case in 2010. And in both the cases, the Honorable Supreme Court had held that a notification by Waqf is not applicable to non-Muslims. So therefore, the Waqf Act is also not applicable. And so far as the other 3 points are concerned, I think they also did not argue it very seriously, but it was just raised for the sake of raising. But the fact of the matter is, we had dealt with all the submissions. We had given our written compilation, written submissions. Detailed hearing was conducted, and now the way for a trial in this case has been paved by the Honorable Allahabad High Court. I must also tell you that there is a order passed by the Honorable Allahabad High Court so far as the survey is concerned.
Yes.
That order has already been passed by the Allahabad High Court.
But stayed
The
by
Honorable
the Supreme
Supreme Court has stayed the matter,
Yes.
and the precise argument of Shahi Idgah Masjid before the Supreme Court was that first 7/11 should be decided, then only any survey exercise must be conducted. So we will be approaching the Honorable Supreme Court and we will be seeking vacation of the stay order passed by the Honorable Supreme Court, as well as we will be filing the caveat so far as the present order is concerned.
Right. So you will be approaching the Supreme Court to try and vacate that stay. Thanks for letting us know that. But Harishankar Jain ji, out of these 18 suits which now find maintainability in the eyes of the Honorable Allahabad High Court, which is the most critical or important one, where perhaps this whole argument about the Waqf Act or the POW 1991 would have come into play?
Because one of the case, I am myself plaintiff. I am myself petitioner.
Yes.
The question is very simple. That we are seeking a right over the property. The question of title.
Yeah.
The Muslim party want that our case should not be decided, dealt with by evidence. Because they know the evidence comes, it is proved to the hilt that it was a temple, it is a temple, and they have encroached upon the land of the temple. They will be out. Original Karagar, where Lord Krishna born, they are still under their position. So it will be proved by evidence and by survey. As Vishnu told you, that order for survey has already been passed on 15th December last year. And the only thing on which the Supreme Court stayed, that 7/11 is pending. Let us 7/11 be decided. Now it has been decided. Then no other. Second thing, Place of Worship Act, whether it is a monument under the Act or not.
Right.
Question is the religious character of the property.
Yes. Religious character.
Religious character of the property has to be determined. For that, evidence required. We will prove that there are katina of decisions and there is number of artifacts in the building itself which will prove the Hindu temple. All the characteristics of a Hindu temple. The signs, symbols, artifacts, everything is there. Our application, we have mentioned all those things.
Right.
That will be seen.
So you are saying there is enough evidence, even physical or visible evidence, to prove your case, but will all these 18 suits be heard simultaneously?
All are connected, consolidated under Order 4 to Order 2-4A, and there is provision that if number of suits are filed, they have to be consolidated.
Right.
In Kashi also, all the suits have been consolidated.
Right.
In Ajodhya case also, all the suits are consolidated, and all the parties will have right to give the evidence.
Okay.
And defendant has right to defend, to rebut the evidence. Now the way to prove the case, that has been opened. But Muslim party is fearful that as soon as evidence comes, everything will be out. And they do not want it.
So your argument is that the Muslim Paksh is trying to block the presentation of evidence, but they also have the right, Vishnu Shankar Jain, to take the entire maintainability aspect to the Honorable Supreme Court.
See, the High Court has given a very, very detailed judgment. And I think it's a very, very well written judgment. We are also in the process of reading and analyzing it. But the argument which transpired in the court in these 4 months, I think it was a very, very detailed hearing. And all the aspects were heard and judgment has been delivered on all the points. So I don't think that there is much scope of interference. But definitely the Shahi Idgah Masjid has their legal remedies before the Honorable Supreme Court. And if they approach the Honorable Supreme Court, we will also be present there and we will make our submissions. So, so far as the merits are concerned, we have a very strong case, but definitely every party has the right to exercise their legal remedy.
True, but many also say, why rake this up? Because there's a settlement that's been reached already. The 1968 settlement is talked about. What happens on the 12th of August? Vishnu Shankar Jain.
The basic contention we have is this, that this is the land of the deity. The custodian of this land is Lord Krishna, so no one has the right to alienate this land. Point number 2 is, if you see the fact sheet of this case, The Sri Krishna Janmabhoomi Trust was the custodian of this property, and the 12th of October 1968 compromise has not been signed or entered into by Sri Krishna Janmabhoomi Trust.
Right.
So these are the basic points. The Allahabad High Court has given a verdict in 1993 also that this compromise can be challenged before the court. We have challenged this compromise, and when the trial will begin, we will prove our case before the Honorable.
Harishankar ji?
One thing I made.
Ji.
Fraud vitiates everything. Fraud vitiates everything. In this case, fraud has been committed
Okay.
by one party of this side and other party. That at that time there were some politicians interested in the matter. Mr. Dwarka Prasad, Mr. Hengar, they are well-known politicians, and they all manipulated everything to do something in favor of Muslims and resulted in the so-called compromise. And if fraud was committed with the society at large, and Supreme Court said that fraud vitiates everything.
Right.
That is null and void. Number two,
Ji.
as you asked, our astha, our belief, right to worship, that is going on since ages, hundreds, lakhs of years, thousands of years, and that is still there. And we pay homage to the birthplace of Lord Krishna, not only going there, from outside also. We have a right to get the original place of birth of Lord Krishna. That is the case.
True. Harishankar Jain ji and Vishnu Jain, my final question to the two of you, from the perspective of law and the test of legal scrutiny, is this case of Krishna Janmabhoomi compared to Ram Janmabhoomi and Gyanvapi or even the Bhotshala simpler or more complex? Harishankar ji.
We have collected number of materials, a number of cases, and we are going to fight all those cases with respect to numbers. It may be 100, it may be 200, in which after demolishing Hindu temple, mosque has been constructed. We will take up each and every case, all over India.
Right.
We have taken up, as you have said, Madhya Pradesh, UP, Adhika Pradesh, Bihar with that number of cases. We are going to take all the cases and a place to get all the temples back. We are not claiming anything of the Muslims. We are
Right.
claiming which are ours. And you entered into the temple, you usurped the premise of temple, therefore you are encroacher. And encroacher has no right to remain. It may be 100 of temples. I
Right.
don't care. But our work is going on. And I, Vishnu ji, and thereafter others, a number of the good team, I will get it back. And Matrija, Kasi, Mathura, Bhoshala, Tijalali Masjid, number of things. There we go.
So your point is that you're only fighting for what you believe belongs to the Hindus and should be returned to them or should be rightfully with them, belong to them. Vishnu Jain, your thoughts on the complexity of this case?
Then to Gyanvapi, then to various other cases, the more you are coming down in history from 1528 to 1670, it becomes easy to prove your case. And in Krishna Janmabhoomi, we have lot of documents to prove our case. So I think the facts of this case are more stronger than Ram Mandir. It's more clinching than Ram Mandir. Here we have the Farman of Aurangzeb, where he has admitted that he has demolished the Krishna temple. In Gyanvapi, we have Farman. The structure itself is saying that it's a precincts of a Hindu temple. So it's our job is becoming easy so far as other cases are concerned.
Right. Vishnu
And
Shankar
definitely we have
ji.
the benefit of the verdict of the Honorable Supreme Court delivered in Ram Mandir.
Ji. So the fight will be fought in the courts now with the maintainability upheld. Vishnu Shankar Jain and Harishankar Jain. Thank you very much. Namaste. Staying with Uttar Pradesh, but shifting focus from Allahabad High Court and its verdict around Mathura and Krishna Janmabhoomi to Lucknow. Have a look at these visuals coming from Gomti Nagar, one of the poshest areas where a lot of the VVIPs reside. A mob is splashing water on a passing couple. There is the man and the lady there, and they try to not just splash water at them, they drag them down and drag the lady down. They try to pull the bike from behind. The woman and her friend lose balance, fall. The woman's friend is seen pleading with the mob. The woman is actually groped, harassed by the mob. The cops crack into action or get into action mode only later, where a lot of these people are then lathi charged. 4 accused based on CCTV footage have been nabbed in the case. Uttar Pradesh Chief Minister Yogi Adityanath spoke about this incident and also named some of the arrested accused. On the floor of the House, listen in.
कि जो गोमती नगर की घटना है, उस घटना में भी हम लोगों ने जवाबदेही तय की है। उसके अपराधियों की सूची भी मेरे पास आई है। ये अपराधी हैं। पहला अपराधी है पवन यादव, दूसरा अपराधी मोहम्मद अरबाज। ये सद्भावना वाले लोग हैं, यानी सद्भावना। अब इनके लिए सद्भावना ट्रेन चलाएंगे, इनके लिए बुलेट ट्रेन चलेगी, चिंता मत करो। और उस बुलेट ट्रेन की तैयारी की जा रही है और इसीलिए महिला सुरक्षा हमारे लिए सर्वोच्च महत्व रखता है। हमने इस बात को पहले दिन कहा है। हम लोगों ने इस बारे में हम लोगों ने आश्वस्त किया एक एक बेटी को, एक एक बहन को।
Short break here on the right stand. When we come back, big news, inputs of infiltration attempts and bids and launch pads who are at the ready to launch as many as 500 terrorists onto Indian soil. Stay with us for these exclusive details.
माई भाई, मैंने भी इस बार SIP करके म्यूचुअल फंड में पैसे डाले। तो मुझे ये जानना था कि KYC का चक्कर क्या है।
म्यूचुअल फंड सही है .com या अपने म्यूचुअल फंड की वेबसाइट पे जाओ, पैन नंबर डालो और सिर्फ इतना देखो कि तुम्हारा KYC स्टेटस रजिस्टर्ड है या वैलिडेटेड।
रजिस्टर्ड हो तो
आधार और पैन कार्ड के साथ अपना KYC वैलिडेट करो, जरूरी है और ज्यादा वक्त भी नहीं लगता।
और वैलिडेटेड हो तो
सही है।
सही है माई भाई। अब तक इन्वेस्ट किया ना हो तो
KYC कर लो और मैदान में उतरो।
सही है।
म्यूचुअल फंड निवेश बाजार जोखिमों के अधीन है। योजना से जुड़े सभी दस्तावेजों को ध्यान से पढ़ें।
As Minister, now shifting our attention to another brilliant piece of news coming in from Paris Olympics 2024. Another bronze for India. This is India's Swapnil Kusale, who's bagged a bronze in the 50-meter 3P event, and also the first such medal that India has managed to win in this particular category. India so far has had no medal in the 50-meter 3P event. Remember, as far as 10-meter rifle is concerned, and in the latest 10-meter pistol as well, India has been able to prove its mettle. But the first medal ever for India in the 50-meter 3P event, and this is Swapnil Kusale winning a bronze for India this time around. It was a rough start for Swapnil Kusale as far as the medal round is concerned, but the last few shots, ever since the elimination round began, he pretty much has been steady at number 3 and now winning a bronze for India. Great news coming in, a third bronze for the country after Manu Bhaker in 10-meter pistol. Followed by Manu Bhaker and Sarabjot Singh combined in 10-meter pistol mixed team event. Now Swapnil Kusale bagging a bronze in the 50-meter 3P event. Another bronze, which means 3 bronze medals for India at the Paris Olympics 2024. This is great news coming in for the shooting contingent. All 3 medals so far, remember, have come in from shooting in different events. All 3 different events: 10-meter pistol, 10-meter pistol mixed team, and now 50-meter 3P event. The family, of course, taking to celebrations already. Let's quickly cut across live to live reactions coming in.
मला खात्री होती मला खात्री होती की गेल्या 12-13 वर्षाची स्वप्नची तपश्चर्या, त्याचं जे कष्ट आहे तो कधीही भुलणार नाही आणि आपला तिरंगा झेंडा तो कधीही खाली पडू देणार नव्हता याची मला खात्री होती. भले तो तिसरा आला तरी चालेल, पण त्यानं तिरंगा झेंडा आपला फडकत ठेवलेला आहे याचा मला अभिमान वाटतो. धन्यवाद.
भारत देशात सगळा झेंडा पत्करला याचा अभिमान आहे मला. जय हिंद, जय महाराष्ट्र.
वाटत आहे की माझ्या भावाने आपल्या देशासाठी ब्रॉन्झ मेडल मिळालं, त्याबद्दल मी सर्व देशवासियांचे आभारी आहे आणि पूर्ण सगळे जगातले ज्यांनी ज्यांनी बघितले आहे त्यांना सर्वांचे मी मनपूर्वक आभारी आहे.
काय कशा पद्धतीने सपोर्ट केला तुम्ही फॅमिली म्हणून?
गेले अनेक वर्षे, गेले 14-15 वर्ष आम्ही त्याच्यासाठी जे परिवार कष्ट सुचलेलं आहे ते आम्ही शब्दामध्ये बोलू शकत नाही. फार मोठा तपश्चर्या आमची आहे आणि यामध्ये त्याचं फार मोठं कष्ट जे आहे त्याचं कष्ट फार मोठं आहे हे आम्ही विसरून चालत नाही.
मोठं योगदान याच्यामध्ये वाटतंय आपल्याला. आपलं योगदान तर आहे, पण
आमच्या परिवाराचं योगदान आहेच. त्याशिवाय त्याच्या ज्या कोच मॅडम आहेत, दीपाली देशपांडे मॅडम, हे यांचं फार मोठं श्रेय आहे. कारण त्यांना परवाच गुरुपौर्णिमेची बोलून दाखवलेलं आहे की माझ्या त्या कोचच नाहीत दीपाली देशपांडे मॅडम, तर त्या माझ्या आई सुद्धा आहेत आणि तेवढ्या माझी ते काळजी घेत आहेत. त्यामुळं दीपाल देशपांडे यांचं तितकंच आमच्या इतकं त्यांचं ते श्रेय आहे असं मी समजतोय आणि साऱ्या देशवासियांच्या शुभेच्छा आणि त्यांचं प्रेम आहे. यामुळे हे त्याला पुण्यही मिळालेले आहे. माझी आई, माझे आजोब, माझे वडील या सर्वांनी मेहनत करून आम्हाला मोठं केले. माझ्या दोघा भावांना, आम्ही दोघे शिक्षक आहोत आणि त्यांच्या कष्टाचं शीज झालेलं आहे. आम्ही आता मॅच बघताना अगदी आमच्या डोळ्यातून पाणी येत होतं. खरोखर आम्ही सुवर्ण पदकाच्या आशेनं बघत होतो, पण दुर्दैवानं आम्हाला मिळालं नसो. पण माझा तिरंगा झेंडा माझ्या मुलग्यांना खाली पडू दिला नाही याचा मला सार्थ अभिमान वाटतो.
Back on, ladies and gentlemen, with news of massive infiltration bid that is going to be attempted or is being attempted by Pakistan. Foreign terrorists are present in Jammu and Kashmir and also parts of North Kashmir, including the Jammu region. Machal, Keran, Uri, Hiranagar are active areas. There's fresh infiltration that's been noticed in North Kashmir. Several Pakistani launch pads are active at the IB and also the line of control. 500 terrorists are poised for infiltration. Terrorists are highly trained, heavily armed. In fact, arms left by the US in Afghanistan are being used. This is confirmed intelligence input that we've received. Our security affairs editor Manoj Kumar Gupta getting us these details. Lashkar and Jaish terrorists are hiding in the mountains. Terrorists are using new names to hide their identity. Terrorists primarily using weapons like AK-47 and M4. Top intel sources are giving us these inputs. We have also accessed pictures of POK launch pads. Heavily trained terrorists seen before infiltration. Those are images of them trying to come across. Heavily armed terrorists waiting to infiltrate. This is all along the IB and also the LOC. Terrorists are at the forward posts of Pak Army in the Tattapani sector of POK. There is also terrorists taken to the launch pad in a Pak Army vehicle. There is confirmed intelligence on that, and there is more. The army and the cops, the forces working together have been able to bust a terror hideout in the Rajouri sector. Terror hideout in Kalakot area has been busted. Exclusive visuals of arms and terror hideouts have been accessed here at CNN News 18. Recoveries in the upper reaches of Kalakot are now confirmed. We have access and information about all of this. Is this all building up to yet another conflict in that region? Anand Ranganathan ji stays on with us, and we are also joined by Brahma Chalani ji, strategic affairs expert. Namaste and Jai Hind. Thank you for staying on with us, Dr. Ranganathan. But first to Brahma Chalani ji. Are we reading the signs correctly? This build-up that is happening, it's got all the makings of yet another conflict in that region.
Anand, it's apparent from the stepped-up terrorism in Jammu region that Pakistan is up to greater mischief. Pakistan is stepping up its infiltration of terrorists into India, and India's counter-terrorism efforts cannot succeed unless infiltration is stemmed. This is a serious issue. Now, we are mounting counter-terrorist operations in the Jammu region without inflicting costs on Pakistan. Those operations will not succeed unless we begin imposing costs on Pakistan. That's the first thing. The second is that in response to the stepped-up terrorism in the Jammu region, we have deployed more army troops in the Jammu region. Now, this is a disquieting development because the army's primary responsibility is not combating terrorism. We have several different types of paramilitary forces that should be engaged in counterterrorism operations. The army should be there for only a short duration, and especially to inflict costs on the sponsors of terrorism across the border by carrying out cross-border raids, what in the past have been called surgical raids. Not a one-off raid, but a series of raids that seek to impose escalating costs on the sponsors of terrorism. Without these two things happening, I'm afraid treating the stepped-up terrorism as a law and order problem will get us nowhere.
But in this case, how do we tackle this? Because we are seeing this build up, Brahmachalani, and very clearly Pakistan is getting, somebody's pushing them, somebody's funding this. They themselves are bankrupt. Even if their drug money or their parallel economy money, they have to use it back in their own economic system. Is this the West trying to deliberately stir the pot here?
Well, certainly the West has not contributed to taming Pakistan. The Biden administration has rewarded Pakistan in a couple of ways. First, by helping Pakistan secure IMF bailouts, not one, but two different massive bailout packages have been granted to Pakistan, and by modernizing Pakistan's F-16 fleet to make it more lethal against India. But more likely is China, which is seeking to ease pressure on the Indo-Tibetan frontier by trying to open another front against India through Pakistan. So it's quite possible that at the instigation of China, Pakistan is doing this. As we all know, Pakistan is so bankrupt, so in such a hopeless situation economically and even politically at home, it's in a bad situation. And yet, it's up to greater mischief with India. And obviously, the only explanation for this is that external forces are behind Pakistan's mischief making against India.
Dr. Ranganathan?
I have a couple of points to make. Of course, I speak as a layman, as a common citizen, and Dr. Brahma is, of course, the expert here. But let me start by saying that, yes, of course, Pakistan has very little cost to incur while it pushes the terrorists. But again, why wouldn't it like to push terrorists towards India? Why it wants India's destruction? And I've said this before, Kashmir is a snakes and ladders game, Anand. The ladders are provided by Pakistan, but unfortunately the snakes are provided by India. Now you can provide as many ladders as you want, Pakistan can, but if the snakes weren't there in India, those terrorists wouldn't come. I ask you, India has a border with Pakistan, from the states of Kashmir, Punjab, Rajasthan, Gujarat. Why is it that only the border that is of Kashmir with Pakistan pushes these terrorists? Of course, there is homegrown support for it. So I do agree with Dr. Brahma that we have to act against Pakistan as well. I would like him to specify what would that mean. Would it be relooking at the Indus Water Treaty or what? But as far as domestic is concerned, even though after the 370 abrogation, we have seen 87% decline in stone throwing incidents, 48% decline in terror incidents, but 48% increase in ceasefire violation. So obviously Pakistan is itching to foment this, but it cannot do it if we Indians would not be supporting it. Now, what do I do about that? That is also one of the solutions we have to take into account.
You make a fair point. The thing is that in our own residences, to keep our homes safe from pests, we do once a quarter pest control. Here you can't do it once in a decade or once in half a decade. So that's what Brahmachalani ji was saying right now, that we should do periodical pest control and we should do it in such a way that there is no build-up of pests that happen. But now what do we do, Brahmachalani? Final word from you, sir.
There are two options for India. One is direct military action and other is indirect military action. Direct military action can impose quite sustained and intense costs. But a direct military action will have to be a one-off operation and it will definitely invite Pakistani retaliation, as happened with the Balakot airstrike. But with indirect military action, which is essentially covert, you can keep imposing costs on a sustained basis and you would have deniability. So in my view, we need to exercise option number 2. And exercise number 2 is an option involving not just the intelligence assets. Regular army troops are trained for cross-border missions.
Right.
So we can impose all sorts of costs, but we need to impose costs on a sustained basis. Unfortunately, we have to accept the reality that despite all the big talk in India, we have not imposed the costs on Pakistan. Otherwise, there would have been no escalation of terrorism in the Jammu region.
Fair point made, sir. We have to make them not just realize the cost, just hurting them economically won't be enough. I keep saying this pest control and this extermination has to happen before they enter our doorstep or enter our sovereign territory. Thank you, gentlemen. Always a pleasure speaking with both of you. Thank you very much. Winding up this edition of The Right Stand on that note. Stay with us. Brass Tacks follows.
माई भाई मैंने भी इस बार SIP करके म्यूचुअल फंड में पैसे डाले तो मुझे ये जानना था कि KYC का चक्कर क्या है।
म्यूचुअल फंड सही है .com या अपने म्यूचुअल फंड की वेबसाइट पे जाओ, पैन नंबर डालो और सिर्फ इतना देखो कि तुम्हारा KYC स्टेटस रजिस्टर्ड है या वैलिडेटेड।
रजिस्टर्ड हो तो
आधार और पैन कार्ड के साथ अपना KYC वैलिडेट करो, जरूरी है और ज्यादा वक्त भी नहीं लगता।
और वैलिडेटेड हो तो
सही है।
सही है माई भाई, अब तक इन्वेस्ट किया ना हो तो
KYC कर लो और मैदान में उतरो।
सही है।
म्यूचुअल फंड निवेश बाजार जोखिमों के अधीन है। योजना से जुड़े सभी दस्तावेजों को ध्यान से पढ़ें।
External Affairs Minister, now shifting our attention to another brilliant piece of news coming in from Paris Olympics 2024. Another bronze for India. This is India's Swapnil Kosale, who's bagged a bronze in the 50-meter 3P event, and also the first such medal that India has managed to win in this particular category. India so far has had no medal in the 50-meter 3P event. Remember, as far as 10-meter air rifle is concerned, and in the latest 10-meter air pistol as well, India has been able to prove its mettle. But the first medal ever for India in the 50-meter 3P event, and this is Swapnil Kosale winning a bronze for India this time around. It was a rough start for Swapnil Kosale as far as the medal round is concerned, but the last few shots, ever since the elimination round began, he pretty much has been steady at number 3 and now winning a bronze for India. Great news coming in, a third bronze for the country after Manu Bhaker in 10-meter air pistol, followed by Manu Bhaker and Sarabjot Singh combined in 10-meter air pistol mixed team event. Now Swapnil Kosale bagging a bronze in the 50-meter 3P event. Another bronze, which means 3 bronze medals for India at the Paris Olympics 2024. This is great news coming in for the shooting contingent. All 3 medals so far, remember, have come in from shooting in different events, all 3 different events, 10-meter pistol, 10-meter pistol mixed team, and now 50-meter 3P event. The family, of course, taking to celebrations already. Let's quickly cut across live reactions coming in.
मला खात्री होती मला खात्री होती की गेल्या 12-13 वर्षाची स्वप्नची तपश्चर्या, त्याचं जे कष्ट आहे तो कधीही भुलणार नाही. आणि आपला तिरंगा झेंडा तो कधीही खाली पडू देणार नव्हता याची मला खात्री होती. भले तो तिसरा आला तरी चालेल, पण त्यांना तिरंगा घेऊन आपला फडकत ठेवलेला आहे याचा मला अभिमान वाटतो. धन्यवाद.
भारत देशात सगळा झेंडा फतकरला त्याचा अभिमान आहे मला. जय हिंद, जय महाराष्ट्र.
CNN News 18 and Federal Bank Primetime Studio.
Good evening. This is Brass Tacks. I'm Zaka Jacob. We're coming to you live from the CNN News 18 and Federal Bank Primetime Studio. The Supreme Court today, in a landmark ruling, has said that there has to be a subcategorization among scheduled castes and scheduled tribes for who is the most deserving for reservation. The court ruling was by a 7-judge constitutional bench in a 6:1 majority judgment. Also said that quota within quota is permissible, that SCs and STs cannot be considered as one homogeneous entity. But perhaps the one controversial part about today's judgment is that the court has extended the logic of creamy layer, which is so far, this concept of creamy layer so far has only been applicable for OBCs. Now the court is saying that creamy layer has to apply to SCs and STs as well. And that the creamy layer, those who have availed the benefits of reservation among SCs and STs, have to be taken out of the purview of affirmative action or the fold of affirmative action. But for all this to happen, first there has to be enumeration, which means there has to be a census, and then which means there also has to be a caste census, because how do you identify those groups for subcategorization if you do not have a caste census? That, the opposition is saying, the BJP is loath to announcing. So,